As you know, we're here to give you a briefing on our brand new report, All Faiths and None, A Guide to Protecting Religious Liberty for Everyone. And, again, there's a lot going on today. We know that it's hectic times, so we do appreciate your attention. My name's Liz Reiner Platt. I'm the director of the Law, Rights, and Religion Project, or LRRP. And for those of you who are new to us, LRRP is a law and policy think tank that's based in Columbia Law School, and we promote religious freedom, religious plurality, and social justice. And we're really thrilled and honored to be partnering on this report and this briefing with Auburn Seminary and Dr. Keisha McKenzie.
Afternoon, I'm Keisha McKenzie, Senior Vice President of Programs at Auburn. Auburn is a multi-faith leadership development center that equips leaders of faith and moral courage, intervenes strategically in communities, and works for social impact within the multi-faith movement for justice. What we dream of is a world where all belong, and we're really excited to work with LRRP on this report and the media guide.
So we're going to go ahead and share some of the background on the report and as well as some of our more specific policy recommendations that are contained in it. And we're going to finish up with plenty of time for questions. So as you probably know, because you're here, All Faiths and None outlines our recommendations on how an incoming presidential administration could protect religious liberty rights, but we intended it to be not just a list of nitpicky policy suggestions, regulations, executive orders, etc., but really what we want the piece to do is be an overall framework for understanding how religious liberty rights are supposed to work so that they can protect individual religious freedom, religious faith communities, the non-religious, and also other fundamental rights that are equally important, like the right to equality. And knowing that all of these various rights and liberties can sometimes be in tension with one another.
We also know that religious freedom is sometimes described in terms of battle metaphors. One of the phrases often used is religious freedom used as a shield and not a sword, even under the best of conditions. But what would it be like if we were to ground our view of religious freedom in terms of what enables flourishing communities? What if we were to begin the conversation by focusing on interdependence and relationship? All of the recommendations we're making in this report are structured around a set of 6 overarching principles that we wanted to guide an expansive and constructive understanding of what religious liberty can be, what it is, why we need it, and what its limits are in the communities that we are in, and communities that are all diverse. So the 6 principles we discuss in the report are that religious liberty must first be neutral, non-coercive, non-discriminatory, not absolute, democratic, and pluralistic.
And the reason that we felt that offering this larger framework on religious liberty rights at this moment in time is that in recent years, we've noticed really an overwhelming focus in every realm, particularly in state and local government, but also in the court system and to a large extent in the media, on religious liberty issues involving just a narrow set of believers, and namely focusing on those issues that are most important to socially conservative white Christians. So really we're talking about opposition to abortion and to LGBTQ rights. And because of this focus, we've seen the term religious liberty itself, which is a fundamental right and is a right that most Americans recognize is extremely important, subverted, and in some cases, I think unintentionally, but subverted to mean almost its exact opposite. That is government support for, if not outright endorsement of, particular theological beliefs and positions. And so what we wanted to do is, again, take a step back and provide not just some of those nuts and bolts policy ideas, but this larger vision to make sure that when we're talking about religious liberty, we're talking about the religious beliefs and rights of all communities. I do want to know briefly that we first conceptualized these 6 principles in an earlier LRRP report published last year called Whose Faith Matters? The Fight for Religious Liberty Beyond the Christian Right. And what that report does is offer a pretty sweeping overview of the many progressive and humanitarian rights movements that have fought actively for a right to religious liberty and a right to practice their faith by, for example, providing water to migrants crossing the desert in the US South, the religious right to perform same-sex weddings in the years before Obergefell, to engage in anti-war activism, a whole list of different kinds of movements that have fought for that right. And then one last thing I want to make very clear at the outset before we start going through these principles one by one is that while we definitely do suggest repealing many of the religious exemption policies that have been promulgated over the past several years and that have been really used to undermine LGBTQ and reproductive rights, the report does go beyond that and discusses religious liberty issues that have sometimes been ignored or frankly not even seen as religious liberty issues at all by some politicians across the political spectrum. So we talk a lot about the over-surveillance of Muslim communities in all sorts of ways, about the environmental destruction of land that is sacred to Native communities, and the lack that we talk about the lack of legal support for folks making asylum claims based on religious persecution, and many other issues.
In the preface to the report, which you'll see linked online, we also begin with a values statement, a statement acknowledging that we live in an increasingly plural society and that we're also here in this particular moment, a moment where the country is actively exploring the distances between founding ideals, our historical practice, our present state, and our future potential. When we look at what the future might look like, we're also listening to demographers who note that the population is changing. What some people call a browning of America, expected to shift the majority between 2030 and 2050. Surveys also note expected decreases in the percentage of the population that identifies as Christian, increases amongst those who are religiously unaffiliated. So with all these shifts in the works, questions about what we base our common values on and the stories and languages that we use to knit our communities together, both in the law and beyond the law, how we will treat one another across difference, those questions are becoming more and more important. What I'd like to think and hope is that as we look at the ways that the laws of this country have been written, the ways that they're litigated and interpreted, and the ways that they're enforced, we can work to ensure that our laws do express our best and most generous values. So what we've done is to build this report assuming that we should build our religious freedom work on a fundamental foundation of care and stewardship of the resources that we hold in common and protection of the marginalized. So Liz, please take us through how these ethics could play out in the principles that we've identified.
So we're gonna take a look through each of these 6 principles and then talk about just a couple of the policy recommendations that we've sort of nestled under each of the principles, but there are many more again in the report. So the first one, religious liberty must be neutral. Both religion clauses of the First Amendment, the Free Exercise Clause, which protects our right to exercise our faith, and the Establishment Clause, which protects separation of church and state, which of course is also essential to religious liberty. Both of those clauses mandate that laws and policies apply neutrally to people of all faiths and to those of and to non-theists, atheists, and humanists and others. So the government can't single out certain theological communities or religion overall for special persecution or for special protection. Now, this seems like a really obvious one, but we found a lot of policies that we think currently violate this principle. So we recommended that the future administration withdraw, or at the very least fix, some of the many policies, not just, of course, the Muslim ban, but parts of the Patriot Act and other immigration, criminal justice, and counterterrorism laws and policies that either intentionally or in practice target American Muslims. So again, to give you just one tiny example, we said that immigration agents should be prohibited from targeting folks at the border and asking them intrusive questions about their religious beliefs and practices. We argued that the administration should eliminate religious exemptions that outright favor certain religious beliefs. So a strong example of this is a recent policy promulgated by the Department of Health and Human Services that provides extraordinary protection to those medical providers who are religiously opposed to providing contraception and abortion. But the same policy offers no protection or almost no protection to providers who want to provide these services, but work at a facility that bans them. So we argue that that kind of one-sided religious exemption violates the neutrality rule. And then one last one for the neutrality principle, we explain that the government really has to treat religious litigants in court neutrally. So we've seen the DOJ in recent years aggressively challenge religious liberty claims when they're brought by progressive faith actors. In several cases, we've actually seen the DOJ attack the religious beliefs of these actors, arguing that they're really political and not religious at all. On the other hand, they've been filing brief after brief after brief in support of conservative Christian litigants. Actually, even in cases when these litigants are going up against other parts of the federal government, like the EEOC. So we argue that the administration needs to be treating all religious litigants with neutrality rather than picking and choosing which they think are really religious or sincere. So the next principle is that religious liberty has to be non-coercive. The very purpose of having religious liberty protections at all is so that individuals are allowed to follow their own consciences rather than being coerced to abide by doctrine that's imposed either by the government or by their fellow citizens. So, certainly we recommend withdrawing different policies like a recent Department of Ed and military regulations that could allow proselytizing and other inappropriate religious activities from public school teachers and military officers. But we also talk about religious coercion by fellow citizens. So we think that some religious exemptions, which are intended to protect religious liberty, in fact violate this new anti-coercion principle. So we think this happens when the government enacts an exemption that effectively conscripts one person into supporting the religious beliefs and practices of another party, of religious beliefs and practices that that person doesn't adhere to themselves. It essentially, some exemptions essentially ask people to give up their own legal rights, and again, in order to further other people's religious beliefs. So an example of this would be an exemption policy promulgated by HHS in 2019 that appears to allow doctors to actually withhold medical information from patients if they think that information could lead the patient to seek an abortion. This exemption, it theoretically is intended to protect the doctor's religious belief, but what it really does is limits patients' ability to make their own medical decisions. And it impacts not only their health, but their religious liberty, because it's asking them to essentially give up their right to health information to accommodate beliefs that they don't hold. So it really cuts into their own religious and moral autonomy. And then the last thing is we think that the administration should be doing a much more rigorous job of protecting immigrants from religious coercion abroad by, among other things, ending the absolutely draconian limits that we've been imposing on the ability of refugees and asylum seekers to enter and to stay in the US. And to consider affirmatively granting members of certain persecuted religious groups like the Uyghurs in China some form of legal status.
Our third principle is that religious liberty must be non-discriminatory. So civil rights laws that protect equal access to jobs and housing and education and provide for public accommodations regardless of religion have been essential to ensuring that people of all faiths, especially religious minorities, are able to participate in civil society. So if these protections against religious discrimination are ever undermined, religious minorities might be chilled in exercising their faith. So what we recommend in our report is that the administration incoming strongly enforce those religious rights laws rather than undermining them through the mechanism of broad religious exemptions. Our fourth principle would be that religious liberty must not be absolute because no constitutional right is absolute. Some government officials, we've understand, have begun to adopt the concept of religious liberty as the first constitutional right and therefore the most important constitutional right. And that's not the case. So we recommend that a future administration would withdraw any policies that reflect the idea that there's a hierarchy of fundamental rights with religion at the top of those rights, including a recent addition to the US Justice Manual that called religious liberty a paramount fundamental right. And we also recommended the administration renew a commitment to the Establishment Clause, fundamental check.
Our fifth principle is that religious liberty rights should be democratic. So since the very first religious exemption case ever back in 1879, there has been a concern that when we allow folks to violate laws that conflict with their religious practice, there runs a risk of undermining this very notion of democratic law, and could allow, at its most broad, as the court put it back in 1879, every citizen to become a law unto himself. We found that exemptions pose a special concern in this regard when they elevate the religious rights of those who are really already overrepresented in the democratic process. So I'm talking about exemptions, for example, that allow the beliefs of a corporation to impose its values and beliefs on both its workers and its customers. Or exemptions that allow a massive hospital chain, again, to impose its values on the rights of doctors and of patients. So we recommend that the future administration should really do the reverse. That is, in the case where there is some form of a direct conflict, we should really be prioritizing those with less social and less political power. We also recommended that the administration rigorously protect the Johnson Amendment. This is a provision that prevents nonprofits, including churches, from engaging in partisan politics. And it's important because it prevents politicians from using religious organizations as a means of injecting unregulated dark money into political campaigns. And it's really something that's meant to protect church-state separation, both the church from the government and the government from the church. So it goes both ways. And then finally, our last principle is that religious liberty must be pluralistic. And as I discussed earlier, we've seen a lot of government officials attempting to confine the meaning of religious liberty to refer just to this very select set of values, while simultaneously ignoring larger rights of religious minorities and of atheists. So we recommend that the administration shift that focus back to those whose rights are really most at risk of religious persecution. That means those whose practices aren't necessarily always understood and certainly aren't always represented in the legislative process. So again, I mentioned this earlier, but we noted the desecration of sacred Native American sites, both during the construction of the Dakota Access Pipeline and more recently with the construction of the southern border wall. We said that the administration should take initiative to see if there's any way to mitigate the damage that's already been done, and instate new efforts to make sure that we're protecting those sites. Similarly, when it comes to atheists, we noted issues like in 2018, the rejection of a secular humanist's application to be a Navy chaplain. In 2016, the House of Representatives refused to allow an atheist to give a secular invocation at the opening of a legislative session. And we recommended that in light of that, the administration make perfectly clear that the right of religious liberty extends to atheists and to all non-theists. So there's a lot more in the report. We don't want to go on forever. We certainly hope that you'll read it and that you'll enjoy it and that you'll let us know what you think of it. But for now, I want to say thanks again for joining us and open it up for questions. Oh, which I'm sorry, I should tell you how to do that. You can put your questions into the Q&A box, and our wonderful Associate Director, Lilia, will be feeding us your questions. And again, I'll give you that hashtag. It's all faiths and none. You can also submit questions that way.
So while we're waiting for some of the questions to come in, I do have one here for you both. And it's, some people use the term religious liberty and others use religious freedom. So could you tell us if there's a difference between the two, and if so, what that is?
I'll take it, or a first stab, and I'll refer to a lovely article in Religion Dispatches, I believe it was 4 years ago, explaining the use of religious liberty specifically within and among religious conservatives and a certain kind of political conservative. Religious liberty is a kind of more classical, from 18th, 19th century forward, in the frame of political theory that thinks primarily about removing external constraints on an individual. Religious freedom has been more popular on the progressive side of the political spectrum and in communities that are plural, that include people from various social strands and religious traditions. So I came up hearing about religious liberty in an evangelical conservative context, but thinking about what religious freedom could mean among people who were not from my tradition at all. And I think it's just become one of those things similar to the voter suppression versus voter fraud kind of differentiation in political conversation. But when you break down what it might actually mean in practice, people are often grasping at and pointing to very similar dynamics. So the terms itself are used differently in different spaces, but when you actually talk to people and get behind the terms, people are often addressing very similar things.
Thank you. That is really helpful context. I have another question here. Liz, maybe, I don't know if you want to take that one. What would you want to change about the way journalists report on religious liberty?
Yeah, so I think that, first of all, I think there can be a change in focus and a broadening in focus. I'll give you an example of this. So when we saw litigation around, for example, Hobby Lobby, when they were litigating because they didn't want to provide contraception within their employee health plan, you couldn't possibly read an article about that case and that doesn't talk about religion and doesn't talk about the owner's religious beliefs. On the other hand, last year and over the past couple of years, there's a bunch of litigation involving volunteers with the organization No More Deaths, who had been prosecuted for their actions providing food, water, and other services to migrants crossing the desert, and who brought a defense to those charges based on their deeply held religious beliefs, saying that this was a part of their religious practice, and therefore, it was protected activity. I read so many articles that referred to their claim as, referred to them as immigration activists, or really used strongly political language, and didn't even mention the fact that they were bringing this defense based on their deeply held beliefs. I think that's really interesting. And I think that's one thing where I think journalists can say, am I covering all religious beliefs? Similarly, I think when we set up this dynamic of religion versus LGBTQ rights, for example, we miss out on the fact that many LGBTQ people are themselves religious. Many, even more people who are religious do not see their religious views at all in conflict with LGBTQ rights. And so that's just one example of the ways in which I think journalists can sometimes make sure that they're covering a more complete picture of what religion looks like in the US. And of course, I need to note that we actually produced as a companion to the larger report a media guide that specifically goes through how journalists can go through our 6-principle analysis and in order to both hone really rigorous questions for policymakers who are claiming to protect religious liberty, as well as engage in some self-reflection about their own religion reporting and things that they might be missing. So I'd encourage folks, if they're interested in the media question, to take a look at that guide.
Great, thank you. And I just popped the link to the media guide in the chat as well for everyone. I just want to quickly take it back to the religious liberty versus freedom terms. Someone asked someone mentioned that they've always preferred using religious equality, and ask what you think of that.
It's an option. I think the larger question goes to another question I'm seeing, which is how do we actually apply the provisions when we're in the context either of enforcing laws that are passed, or if we're not jurists, if we're not judges and we're not lawyers, what is it that we can do to ensure that there's a climate within our community where people of various traditions and none can still feel like they're participating in the same space from a position of equity. And one group is not privileged because they practice and another is not disadvantaged because they don't. And that's like the larger, how the principle is walked out is the larger question often than the specific term, even though there are differences in terms of what people choose to call it by when they speak. I think the questions about how, even though because of where we've begun as a country, the religious freedom is often used in ways that, as Liz said, disenfranchise humanists and others who don't practice a theistic religion. We still want a space in, as we discuss religious freedom, where everybody can be at the same table.
I'll add one kind of more legalese element to that, which is I certainly, we use religious equality all the time, and I think neutrality to some extent gets at the equality at that framing. But you know, that does raise, of course, as it always does, sort of questions about formal versus substantive equality. So does a uniform code, for example, that bans headwear, does that promote religious equality or not? And I think religious equality is important, but I think it doesn't answer every question that we might be concerned about.
Thank you for adding that legal side, Liz. This kind of is related to a question about how the right to religious liberty applies to atheists specifically, given that the language of the Constitution directly references a Christian God. How do you balance the concept of separation of church and state with the strong religious beliefs that are reflected in our laws, such as the punitive nature of the criminal justice system?
Well, God is referenced in the Declaration of Independence, not the Constitution. But in terms of the religious, I'm very interested in the criminal justice portion of it. Can you repeat that again?
Yeah, sure. Sorry, it's a long question. So it's how do we balance this concept of separation of church and state with strong religious beliefs that are reflected in our laws? And one of these strong religious beliefs that are referenced, the example is the punitive nature of the criminal justice system.
Yeah, I think that goes to the ways that certain values are encoded in particular interpretations of religion and in some religious practices, and that bleeds out into the cultural values that might reinscribe punishment in a criminal justice system versus a kind of redemptive approach. So that kind of gets to why we want to have robust discussion about what are our fundamental community values, so that we don't default to any individual religion's values. And we can debate whether we want a society where the moral code is based on punishment and abandonment and disenfranchisement.
I think that's a beautiful answer. I don't think I need to add any.
Another question we have here is about recommendations regarding how to assess state legislative bills. So this person describes that so-called religious liberty bills, the language in them often seems innocuous and could even sound quite lovely, but the reason for introducing it usually tells a different story. So what do you recommend on how to assess legislative bills through the framework that you've offered?
I would encourage using those principles in the context of advocacy campaigns, local advocacy campaigns. When I was working in the LGBT Christian space, one of the things we would often do is to default to the lived wisdom and experience of people who lived in particular cities that were beginning to issue so-called RFRAs. And it was about making sure that we understood some of that background context, and that would help to shape the ways that a campaign might evolve. I don't have, again, the legal side. I default to Liz on that, but I think it would be important to go into coalition with people who are in a particular context and have a track record of trying to engage state legislators to make their community better, because that's the ultimate goal.
Yeah, I mean, I think certainly you can say intent matters. And I think probably some folks on this call are familiar with Project Blitz, which was a state legislative policy guidebook that offered 3 kind of levels of state legislation, the bottom of which are kind of what you talked about, these things that sounded very nice and pretty innocuous, you know, like a religious liberty day or things like that, and then were targeted to sort of make politicians more comfortable with passing laws related to religion, make the populace more comfortable with these laws, and then they would ramp up to level 2 and then ultimately level 3, which are some of the really outright Christian nationalists favoring particular religious beliefs within our legislation. So I thought that might be just good to go over. But yeah, I mean, I think intent matters for constitutionality. Theoretically, it did not in the Muslim ban litigation trump v. Hawaii. So in some ways, you know, it's a legal realist perspective, I guess. But, you know, I think we can, when we see something that looks innocuous, you know, as Keisha said, bring in folks who have that local knowledge and can give you what is really behind this legislation, why is it being passed, and is it part of a larger pattern that we're seeing across the country that's really intended for a much larger goal.
Thank you so much, both of you. I have another question for you. So in the event that Roe v. Wade is struck down, how could religious liberty be used as a legal framework to defend or preserve access to reproductive rights?
Great question. So absolutely, that's something we've been giving a lot of thought about. I think the writer might be interested in our Whose Faith Matters report, which talks about some of the history of religious activism in the abortion rights movement. And this is actually a tactic that has been used before. So prior to Roe, folks may be familiar with the Clergy Consultation Service on Abortion, which was an incredible network of clergy members who ran a hotline and provided services across the country to folks who needed an abortion and wanted information about a safe way to obtain one. And they sent people both to abortion providers abroad, and in some cases gave assistance to folks in the illegal abortion in the United States, but safe places to obtain it. That's absolutely going to happen if Roe v. Wade is overturned. There have already been religious community members who have said they are out there to commit, civil disobedience and to ensure that people have access to safe abortion, whether it's legal or not. And while civil disobedience, of course, is not asking for a religious exemption, so I probably shouldn't have used that term, but for folks who want to try to use religion and go through the legal system to obtain a right to provide abortion services or to provide information about abortion, that there is some case law to turn to in the pre-Roe era of members of the Clergy Consultation Service who demanded a First Amendment right to provide information about abortion services. That litigation didn't really go anywhere, but there is precedent, and I think absolutely that there's going to be efforts to do that. And frankly, actually have already been some efforts. Folks may be familiar with some of the Satanic Temple litigation, arguing that folks who are members of that group should have a deeply held feeling of right to personal bodily autonomy, and therefore should not have to abide by these over-the-top regulations on abortion in certain states. There was some litigation in Indiana about that folks can check out. And also there was a religious liberty argument in a case out of Baltimore that again argued that that medical providers should have a right to provide holistic reproductive information to their patients. So, I mean, I guess I didn't really give you the how could that happen, the nuts and bolts. I mean, there are different ways. It depends on the state, whether there's a state referral, what the state constitution looks like. But I think absolutely, whether it could happen and whether it will happen, I think it absolutely.
I would also want to consult with communities like the National Council of Jewish Women, because in certain religious communities, there is an affirmative position in favor of providing access to abortion and other reproductive procedures as well. So consulting with those groups that have been thinking about this for centuries in some cases, and not only within the narrow confines of what this current law provides, would be helpful for creating that strategy if it's not already in play.
Thank you both. And we have two more questions. So this one goes, the Supreme Court has adopted a view of the free exercise clause on steroids, eclipsing the Establishment Clause. And this person thinks that the death of Justice Ginsburg will likely accelerate this trend. So in light of that, how can we get back to a better balance between the two clauses, and is expanding the court an option?
It's an option. And, you know, yeah, it's an option. I try not to make predictions because who knows what's going to happen in the next month or the next year. But they're absolutely right. I mean, to some extent, many of the bad decisions in terms of religious liberty issues that we've been seeing aren't coming from the Free Exercise Clause, but from the Religious Freedom Restoration Act. That said, there is a case, Fulton, regarding whether or not a religious contractor with the state can be permitted to use federal dollars and then go around and refuse services to same-sex couples because of their religious beliefs. And that case holds the potential to really wipe out this balance between the Free Exercise Clause and the Establishment Clause. And if that happens, I think we're going to have to come up with new creative solutions, unfortunately. I mean, either the court gets packed, or if we're living with this, with a very right-wing Supreme Court, you know, that's why I think we're giving a lot of thought to the question of how can we use free exercise clauses to protect the communities that we care about. And I think certainly, you know, we're going to continue to advocate for an establishment clause, for a strong establishment clause, but considering the potential realities of the Supreme Court, I think we're just doing our best to try to come up with creative legal solutions with the case law as it stands, while also advocating for a better path. So.
Thank you.
Mm-hmm.
Dr. McKenzie, did you want to add something to that?
I think I was taken by the remaining question that I'm seeing in the queue.
Well, I was going to try to synthesize it a tiny bit. So we have a participant here who is curious about the impact of belief, because it's a central theme in popular discourse, at least here in the States, the discourse about religion and religious freedom. So they wonder, are neutrality, non-discrimination, and pluralism even possible within our popular discourse about religion if it's so credo-centric? So if the way religion is understood in the US so strongly privileges individual affiliation as opposed to communal affiliation, and the way religion is understood privileges faith and belief as opposed to practice or ritual, how do we guarantee that all sincere religious freedom claims can be fairly recognized?
I really love the question. So thank you to the person who offered it. I think this is why we need to be able to build in some of that discourse about the role and definition of religion at fundamentals, so that we can get to the question of what values can help us transcend limiting definitions in the first place. We can't really have a government commit to neutrality if the definition that the government is using to enforce that value is itself so limiting, it leaves so many people out. So we want to be able to privilege the fact that religion can be a practice-based thing. It can be a creed-based thing. It can be a ritual-based thing. And you can have people sincerely holding ethics and moral courage values that don't identify with any of the above. And all of those people living in this country deserve to be treated neutrally and equally by their government. So we can't, from where we stand right now, guarantee that, but we hope through all the mechanisms that we have in play, from the community interventions and the legal route and the litigation when something goes wrong, to shift that definition and to shift that practice in the right end.
Thank you so much for bringing that nuance to the whole concept of religion and faith. And I have one final question. Liz, I think that's going to be you. It's on the legal side. If you could think of an example, so we've talked about these 6 guidelines to protecting religious liberty. So could you think of a specific legal case that could have been or might have been ruled differently if the judge or the justice determining the ruling had kept these 6 guidelines in mind?
Yeah, absolutely. So, gosh, I'm debating between, I'm going to say, I mean, absolutely the Trump v. Hawaii, the Muslim ban litigation. I think a lot of people have pointed this out. But when it comes to neutrality, I think a lot of people have really showed the tension between the court in its Masterpiece Cake Shop decision, zeroing in on one stray comment by one person in the very first decision regarding, and I'm sorry, Masterpiece is the case involving the bakery owner who didn't want to provide a cake for a customer's wedding, and because of his religious beliefs. And the court didn't necessarily say that people are allowed to just refuse services, but what they did is said that this particular man was treated unfairly by the state, that they a stray comment by one of them, by one person who heard his case, and said something like, "Oh, well, it's terrible for people to use religion to discriminate." I mean, it was the comment wasn't even particularly demeaning, but the court said that one comment was so objectionable that they're going to essentially throw out the whole case against this man for violating civil rights law. A couple weeks later, and the court says, we are not even going to look into the abundant evidence of the Islamophobic animus motivating the Muslim ban. We're not even going to really consider it, and we're just going to uphold it because it's facially neutral. So I think that's an area where, of course, neutrality would be doing a lot of work, ideally. You know, and then I'll briefly mention just Hobby Lobby again, because that really hits a lot of them in terms of anti-democratic. Here we are prioritizing the beliefs of the Hobby Lobby Corporation over not just its customers, but also its I'm sorry, in that case, over its employees and their whole families. It's a coercive religious exemption. We're protecting the religious rights of a handful of people at the head of that corporation and asking thousands of people under them to essentially give up their legal rights in order to protect those faith beliefs. And so that's another area where I think it hits a couple of them. Thank you. All right, Lily, so is that it?
Yes, thank you both for those illuminating responses.
All right.
Those are some great questions.
They really were. Thank you so much. Thank you for joining us. We hope you enjoy the report. Please don't hesitate to reach out if you think of other questions. We'd love to talk to you and hear from you. And thank you again for joining us on this late Tuesday.
Take care, y'all.
All right. Bye-bye.